against my brother's lawsuit
That's
for the
a lot
same
of work.
reasons. All right. So they're communicating. And so in the pleadings of my brother's lawsuit, they admitted that the federal court had unfiled my case, that it wasn't just backlog. They admitted it.
Boom.
And so with that information, we took that document from his case and took it to the state court with a full summary judgment motion saying, Judge, look, we've got the proof right here. We don't even need a trial. You can make a decision because it's
Black and
clear,
white.
black
Yes.
and white. Exactly. And so we waited for the judge to make a decision, and he wouldn't make a decision. But here's the state court judge with this incredible opportunity to slam down two federal giants for depriving me or violating my due process rights. And so after several weeks went by, I guess the judge gave in, and he finally made a decision supporting the U.S. attorneys, so dismissing my case. Okay, so here we are, dead in the water again. But a few weeks later, I was notified by the federal court that even though they had won at the state court level, they decided to do what I was suing them to do, and they refiled my case against the 387 defendants. And the chief clerk of the court ordered the state federal court to the chief clerk of the state federal court to issue the 387 summonses, which was completed within 48 hours. And then the U.S. attorneys came on board to battle with us. And that's what we were able to do, go from there, skipping the 10th Circuit Court of Appeals with a Rule 11, which in order to skip a normally required 10th Circuit Court of Appeals, you have to get permission from the Supreme Court of the United States under their Rule 11. And they have to conclude, the clerk's office has to conclude that this is a case of imperative public importance, which they did.
Is that what Rule 11 is?
Exactly.
Okay.
Yeah. So there it is. Okay, now, it got dismissed. Well, I shouldn't say dismissed, because when you appeal to the Supreme Court of the United States, they can deny a hearing. Okay. So they deny a hearing. So what you can do is you file another petition saying, hey, we want another shot at this. This is important. Please give us another shot at having a hearing. And so you're allowed two, and sometimes you can get more than two. So my brother's case was denied twice. Mine was denied once. And then on August 19th, 2023, President Trump retweeted a video of me asking him if he would support my letter campaign at LloydBrunson.com, supporting the Supreme Court justices to do the right thing. These are letters going to the Supreme Court of the United States. That was a Friday. Now, I hadn't had the second conference yet. Another miracle. Exactly. That was a Friday. Now, at this time, the justices are on vacation because it's summer. So they didn't even set a conference date for my second conference. They just said distributed on the when you go to the SupremeCourt.gov and saw that on the docket. And so it's like, so Friday, President Trump supports the letter campaign, my video. The following Monday, the court docket shows denied a conference, or denied a hearing without a conference. It's like, oh my gosh, now we're dead again. What do? We've been killed twice. It's denied a hearing twice, but we didn't get a second conference. And so anyway, so we just kind of felt like, well, this has been important. It's raised awareness, because now we can see, a lot of people can see now that Article 6 of the Constitution that requires a binding oath has been completely ignored, because there's no penalty for breaking their oath, and they're supposed to be.
Can you share with us real quick what Article 6 is of the Constitution? Just refresh people.
Well, if you look at Article 6, I'm talking about the point where it says they shall be bound by oath to this Constitution, talking about federal officers that take an oath to the Constitution. And anyone that takes an oath in the United States, lawyers take an oath to the Constitution.
Okay.
So everyone on even state and local levels take an oath to the Constitution.
Everyone within government.
But Article 6 has the words, they shall be bound by oath to this Constitution. And how can you be bound by oath if they have absolute immunity? And that's what the U.S. attorneys were defending all the defendants on. They were defending the courts with judicial immunity and absolute immunity. But it's like, that's a contradiction. So we're raising awareness, and I'm excited about that fact. But here we are, kind of dead in the water, where I've been denied twice, and my brother was denied twice. And then several months go by, and we have a new administration. President Trump is now president. And I hadn't even thought about, I felt he was going to investigate the 2020 election, and he's already said it's not over. That's going to go on. And so I'm thinking, what could possibly happen now? But then as I got thinking about it, just not too long ago, I thought, wait a second. When the U.S. attorneys were representing the 387 defendants, and we were representing the two federal courts, when it went to the Supreme Court of the United States, the U.S. attorneys are no longer their defense attorneys. There's a new defense attorney that's assigned to take over on the Supreme Court level, and that's the United States Solicitor General. And she was a liberal leftist appointed by Joe Biden. But now with a new president, we get a new U.S. Solicitor General. And I'm thinking, oh my gosh, who is this going to be? And we just kind of waited and waited. And finally, now, just several weeks ago, we have a new U.S. Solicitor General who is President Trump's #1 constitutional attorney, who has actually successfully argued in front of the Supreme Court justices for Donald Trump. His name is Dean John Sauer. And I'm thinking, this is another miracle. It's like that. President Trump knows about this, and Mr. Sauer has to know about this as well, because President Trump would not have retruthed about it twice unless he had got some good legal advice from, I think, Mr. Sauer.
Absolutely. Wow.
So now there's a new U.S. Solicitor General in place, but I'm thinking, we only have possibly four U.S. Supreme Court justices. Amy Coney Barrett, when she was in the Senate hearing, she was asked, what are the 5 protections in the First Amendment? And she couldn't remember the protection that protects what I'm doing. And that is petition the government for redress of grievances. And that's what I'm doing through the courts, petitioning the federal government for redress of grievances. She couldn't remember that. And I thought, gosh, that is so weird. When I heard her forget that, she remembered the 4 others, but she couldn't remember that one. So I'm thinking, we need another Supreme Court justice. And I thought, I wonder if there's a replacement, who that would be. And I started doing a little researching and found out that President Trump has already picked someone. And it's Ted Cruz, the man that instigated the 10-day pause for the 10-day investigation.
Yep.
It's like another miracle.
That's a big one.
That's a big one.
Yeah.
Exactly. And so now that President Trump is determined to get to the bottom of the 2020 election, there's all kinds of speculation in my mind what could happen, because this is a huge tool that can be used to not just for investigation, but for information that could lead to criminal investigation from the Department of Justice happening to a member of Congress. And so that's a huge deal. And so it's like, this is just incredible to think about that. Now, we know that a couple of the justices, their health isn't so good, and some of them have made really bad decisions. So, but with Ted Cruz in place and being able to, well, I've imagined, can you imagine if the 2020 election began to be overturned? It would overturn decisions made by the executive branch, which would include a Supreme Court justice too.
Yeah, that would be wonderful. And that's what should happen, because that's what is right legally. That's what happened. It was fraudulent. It wasn't looked into. It was just swept under the rug. It so wrong. And lawyers, even now, they don't practice constitutional law.
No, and I think this could have a trickle-down effect, like a flood-down effect. Once we get the oath of office enforced as a binding oath, think about it. If you sign a contract and you violate the contract, you have to suffer consequences.
Absolutely.
And the oaths of office over time have included penalties of perjury, have had real teeth, but they've been getting away with it because we, the people, don't understand Article 6 of the Constitution requiring a binding oath. And that brings me to my next subject about my book that I have. I'll tell you about.
Yes. I'd like to ask you first, before we get into your book, when did you start studying the Constitution? Did you always have a passion for that? Or was it like your brother asked you to do this and you just had a spark in you to start studying and learning, and then that desire grew?
Well, it was way before 2020. It started in about 2010. Barack Obama inspired me to study it when he told the world that the foundation of the Constitution was fundamentally flawed. And so I thought, when I heard him say that to the world, it's like, if he were my defense attorney, he could be fired, he could be sanctioned, he could be sued for malpractice because he swore to defend the Constitution. And now he's saying the foundation of it is fundamentally flawed. And so that got me interested in getting into the document. And then I'd watched an incredible documentary called The Money Masters, which explains money and the Federal Reserve in some amazing ways. And I started connecting dots in the Constitution. At first, it was painful to read it. I knew I had to read it. But when I read the oath of the president, that like seeing it in the document itself is much more powerful than just realizing he swore to defend the Constitution. Of course, Obama took a congressional oath. But so that began my study and my passion many years before the 2020 election.
So I think the Lord was probably preparing you for all he had planned in the future, and you probably weren't even aware until all of this came about, right? So
it seems like it.
It seems like we have the Ted Cruz video if you want to play that.
Yes, let's
give a background.
Show that. Okay. Absolutely.
The Senator from Texas, Senator Cruz.
Mr. President.
Senator.
We gathered together at a moment of great division, at a moment of great passion. We have seen, and no doubt will continue to see, a great deal of moralizing from both sides of the aisle. But I would urge to both sides perhaps a bit less certitude and a bit more recognition that we are gathered at a time when democracy is in crisis. Recent polling shows that 39% of Americans believe the election that just occurred, quote, was rigged. You may not agree with that assessment, but it is nonetheless a reality for nearly half the country. I would note it is not just Republicans who believe that. 31% of independents agree with that statement. 17% of Democrats believe the election was rigged. Even if you do not share that conviction, it is the responsibility, I believe, of this office to acknowledge that is a profound threat to this country and to the legitimacy of any administrations that will come in the future. I want to take a moment to speak to my Democratic colleagues. I understand. Your guy is winning right now. If Democrats vote as a bloc, Joe Biden will almost certainly be certified as the next president of the United States. I want to speak to the Republicans who are considering voting against these objections. I understand your concerns, but I urge you to pause and think. What does it say to the nearly half the country that believes this election was rigged if we vote not even to consider the claims of illegality and fraud in this election? And I believe there's a better way. The leaders just spoke about setting aside the election. Let me be clear. I am not arguing for setting aside the result of this election. All of us are faced with two choices, both of which are lousy. One choice is vote against the objection. And tens of millions of Americans will see a vote against the objection as a statement that voter fraud doesn't matter, isn't real, and shouldn't be taken seriously. And a great many of us don't believe that. On the other hand, most, if not all of us, believe we should not set aside the results of an election just because our candidate may not have prevailed. And so I endeavored to look for door number 3, a third option, and for that I looked to history, to the precedent of the 1876 election, the Hayes-Tilden election, where this Congress appointed an electoral commission to examine claims of voter fraud. 5 House members, 5 senators, 5 Supreme Court justices examined the evidence and rendered a judgment. And what I would urge of this body is that we do the same, that we appoint an electoral commission to conduct a 10-day emergency audit, consider the evidence,